Okay, as you all know, if you look at our Freedom Catalog, you'll notice on page 25, there's a picture of a man named Paul Ballmer and a check on the bottom of the page for $337,000, folks. This is real. Paul Ballmer is a great friend of mine, one of my students. We both got started through Free Enterprise Society on the California Franchise Tax Board. He did a great job. And even though the FTB never took a dollar from him, he beat him in court, had the tax lien FTB had on him, California Franchise Tax Board, had it removed, and in addition to that, he collected from him $250,000 and all of his attorney's fees and expenses. Okay. Now, but he hasn't stopped. There's a lot more going on that he's doing. He's going to give you the latest update on his efforts and Freedom Law School's efforts to rein in this out-of-control governmental agency, far worse than the IRS and arbitrary. Please help me give a warm hand of welcome to Paul Ballmer.
Well, Payman's given me 10 minutes, so I have to go kind of fast, hit the highlights. But I just want to tell you a brief story first before I commence, because, ladies and gentlemen, we cannot do this by ourselves. I cannot do it by myself. And on the way down, I just purchased from Dr. Wayne Dyer. He had just completed a new presentation called The Power of Intention. And I put that in my car on the way down here on Thursday night, on Friday rather, and I think this is very critical to the movement, because you'll see in a second, it's not what we intend to do that's important, because when we intend to do something, the ego gets in the way. But rather, he says, it's what we connect with. And his suggestion is that we connect with the source. The source is that power which gave each of us life when the two chromosomes came together. And that power which is incredible, which rules this universe. And he suggests that the connection with that source that we have is contaminated. And so he suggests that we cleanse that connection. And I have to tell you that many times during my lawsuit, I felt that power. And if you were here and listened to Vernie Kukla, you could tell that she did too. And when things get tough, and I can't tell you how many times I've recited that I will trust in the Lord with all my heart and with all my soul. So I just wanted to preface that, because I think that's something that we need to keep in mind in this movement, because we can't do it by ourselves. So I'm going to give you a brief history of what happened. Many of you have already heard the story. Basically, in 1993, I started writing letters under the Information Practices Act. It's the State Privacy Act. It's not in the tax code, generally referred to as the IPA. I wrote letters for 4 years. The state thwarted me, pushed me around, and I came to the decision in 1997 to file a lawsuit. I filed that lawsuit thinking it would be over real quickly, because the information in my file was not accurate, it was incomplete, it was not personal, all the things that are prevented under the Information Practices Act. We lost the first trial, it was dismissed, we went up on appeal, it was remanded back, and 4 years later, 8 years after I started asking the Franchise Tax Board to correct things, we won the second trial. And I received $250,000 in damages, $80,000 in legal fees, and $10,000 in costs and interest. They decided not to appeal it. So I had been working, and I recognized that this was significant, but it's kind of like a drop in a hurricane in the big picture. And so what my thought was, because I had wanted other people to testify at my trial, and Payman was one of them, and the other two, Payman got on the stand for about 2 minutes, and the court would not allow any of them to testify. One of the things that you have to keep in mind that the Franchise Tax Board wants to do, and so does the IRS, they want to divide and conquer. They don't want communication. They don't want people talking with each other. And anyway, so I got the idea that, well, maybe what we should do is have multiple plaintiffs the next time around. And so I had started working with a number of people because there's a lot of groundwork which has to be done on an IPA before you can file the lawsuit, a lot of establishing the violations. And I had started working with these people, and in October, I guess sometime in late September, early October, Payman called me and he said, hey, I just got a call from George Benoit in Sacramento that the state has passed a law prohibiting this kind of a lawsuit. Now think of this. Instead of correcting the violations and their illegal activity, they go to the legislature and con them into passing this law. Well, it was going to go into effect January 1st of 2003. We had about 3 months left. During that time, I worked night and day, and Payman also, and we put together 5 lawsuits which were filed basically on December 31st of 2002, so they're grandfathered in. We will have to litigate that new section of the Revenue and Taxation Code, it's 19570, which we feel we can beat, but that's another issue. So Payman has about 4 or 5 plaintiffs. I have about 7 or 8. We have 13 plaintiffs make up these 5 lawsuits, and they've all been dismissed based upon summary judgment or demurs, and we're working on the appeals right now. So I'm beginning to work with other people for the next go around downstream. Once these cases come back from the appeal, then we will start putting together the next group of plaintiffs. But I'm trying to build on the success. That's the reason for the multiple plaintiffs. First me, now we have 13 plaintiffs. Hopefully the next time we'll have 50, 1,000. That's one of the things that it's going to take. We're going to litigate the authority issue. And the jury, I want to express how important I feel that the jury is. That's one of the most critical things that we can do, because the judges are literally afraid to make a decision against the taxing agencies. So we must get to the jury, even though the juries may be concerned with the fact that there's been non-filing and they're not familiar with these issues. I think that we have a better chance to reason with them than we do with the judge. Another thing that I want to do, based upon one of the plaintiffs that came to Payman and I and asked us to help, that's Judy Welch, and asked us to help her at her deposition. We went to the deposition. They wouldn't do the deposition. They then went and sought a protective order. We won on the protective order, and we were going to then depose two people from the Franchise Tax Board in Sacramento, Kathy Cleek, who heads up the computer system, and also Steve Sue. I had 75 people lined up to come to a deposition on a weekday. Video cameras and court reporters. We were going to, that's one way, in other words, to disseminate the information. Many people can't go to a trial, and this is one way. So we're hopeful that we might be able to do that again downstream. But all these things take money. Also, possibly jury consultants to help define the juries or select the juries later on. We have to do something to capture the public, and you've heard this from other speakers, but we have to think in terms of getting, how do we get this word out? How do people get involved? How do they find out? We don't need everybody in this country, but we need a lot more than we've got right now. So I think that's about my 10 minutes, Payman. I can talk for 10 days if you want, but I'll be around. I have a table over here. We have some of the documentation you're welcome to look at. We're trying to raise some money to help some of the people that have come into the program that are short. Any of your support would be greatly appreciated. If you want to get on the email, I can do that, or we'll do it with Payman's email. And I appreciate very much Payman giving me this opportunity. Thank you.
Thank you, Paul. Next, we're going to bring you an attorney in, a lawyer. Some people call them officers of the court and they think they're all sellouts. Now, I want you to know that's not the case. There's a lot of incompetent lawyers and crooked ones, but there are definitely a few good and competent ones out there. And this one we're going to bring you right now is one of the very best, with a track record of success against tyrants and oppressors. He's assisted Jack McLam. He's had successes against the IRS in bankruptcy arena and criminal cases. And folks, you gotta tap into people who are out there who can help you, folks. You cannot be an island by yourself and be free. It doesn't work that way. It's not like 1830 in the Wild West. Okay, so please help me give a warm hand and welcome to an attorney, a friend of ours from Phoenix, Arizona, Mr. Don McPherson.
This meeting takes me back 25 years. It reminds me of one of my first clients, Bob Judge from New Hampshire. And after getting to know Bob a little bit, and we really love the guy, we turned and looked at one another. This is Mark McClellan, the attorney that worked on the case with me. He's got a higher calling, became a missionary to Guatemala, reached the Quiche Indians. He now teaches seminary in Louisville, Kentucky. We looked at each other, and one of us said, you know, Bob Judge he's brain fried. He's got a John Birch conspiracy under every rock. And that was an expression that kind of stuck with us, because we would come up with other clients and it would be the same kind of story. You know what? After 25 years, there is a conspiracy under every rock. There is. That's what I found out in 25 years. Bob was right. He was burned out. The question is, what do you do about all these rocks, all these conspiracies? You're only one person or one family or brother and sister, husband and wife. My goal today, and I haven't done this before, I've touched upon it, but today I'm really going to hit the nail on the head. I'm here to recruit. I'm here to recruit of good lawyers and good paralegals. Now, we didn't hear any lawyer jokes. You know, I didn't go to law school because I love lawyers. I went to law school because I hate lawyers. So I'm not shy to tell lawyer jokes. You know how to tell when a lawyer's lying? When his lips start moving. I mean, we could tell lawyer jokes till the cows come home, and it would please me. We've heard some lawyer bashing, and lawyers need to be bashed because they are part of the problem. But you know, it's that old expression too, for all of you, if you're not part of the solution, then you're part of the problem. What are you going to do? Are you going to eat, meet, and retreat? I've talked to groups over the last 25 years, and we had an expression for a lot of them. It's eat, meet, and retreat. You can study, study, study. How long do you study? How long do you take in all this knowledge until you reach a point where, well, I'm going to do something? You've seen all these talents brought to bear in this room. All these great speakers, all these great exhibitors, and they all have different niches. And I have my niche, and I'll get to mine in just a moment. And you've got God-given talents, and you've got to decide, with the Lord's help, what's your mission? What are you going to do about it? Isaiah said, who shall I send, Lord? Lord, send me. And that, you know, who shall I send, Lord? Lord, send me. That's been a calling card for me for 25 years, because Mark McClellan and I used to pray when we first had these tax protest cases, and continue to pray with all of them. But we said, Lord, do you want us representing tax protesters? We thought there were more important issues. I still think there are more important issues. What can be more important than murder of the unborn? I would love to be involved in those issues. And I've been involved in many non-tax issues. I'm going to give you a whole laundry list in a minute. Not to brag about it, but to give it to you to use as your recruiting tool, because there's so few lawyers in the freedom movement, and we need more. We need the paralegals and the lawyers. And I'm going to tell you exactly what I think as to how you recruit them. But back to the John Birchers, I had great respect for the John Birch Society. They were always recruiting me. I'm not the joiner type. I'm not a club type or an organizational type that likes to become a member of different organizations. But they kept inviting me to meetings, and I'd go to meetings and I'd hear speakers. And the problem with the John Birch Society, in my view, they're always talking about education, and they're always educating. And I said, wait a minute. Why don't you guys take some action? I mean, I'm trained as an action-minded person. West Point, Airborne, Ranger, Infantry, Vietnam Combat, Platoon Leader and Company Commander, later Special Forces. I'm the guy not going to run for governor. I'm not the guy, Bob Schultz over here, all credit to Bob. Man, the work this guy does. Paymon, Steve, Free Enterprise Society, Clayton, Free America, Willis Carto, what he's done over the years. We all have these different talents. I'm the guy that's going to put on some camouflage on my face, put on a parachute, and get in an airplane, and as a jump master, qualified jump master, I'm going to give that first command. And it's not something like John Wayne said in the movie, well, come on. That's not how it's done. How many here saw the movie, or the series, the tapes, about World War II, the 101st Airborne, Thank you. How many have seen that? Band of Brothers, and I also read the book. In that movie, remember the scene before the Bastogne series, all these GIs in the Battle of Bulge are retreating, and the 101st Airborne comes, and they don't even have the winter clothes, they don't have ammunition. They're saying, give us your ammunition, give us your ammunition. And these guys that are retreating say, where are you guys going? And they said, we're going to Bastogne. And he said, Bastogne? You're going to be surrounded. Remember what the captain said? We're the airborne. We're supposed to be surrounded. Well, that's my mentality. I mean, not everyone in high school wanted to go to West Point. Not everyone at West Point wanted to go in the infantry. Not everyone in the infantry wanted to be a paratrooper. I'm just one of those crazy guys that want to put camouflage on and get on that airplane and take the troops into combat and jump into the, stealth of darkness, undercover darkness, and crawl on your belly with, you've seen the movie, so you've seen it dramatized, but a lot of it's got the truth to it. And if you saw Band of Brothers, that movie is the most poignant movie that I've ever seen that really describes A, the spirit of the airborne, and B, what troopers in real combat go through without a lot of the hype and so on. So I would encourage you to watch that sometime, because you'll better understand how I feel when I deal with agencies such as the Internal Revenue Service. I'm ready to put on my war paint. And it's not, a psychologist would have a lot of fun with this, but I guess it's a lot of it, frankly, is I'm getting even. Psychologically, subconsciously, I'm getting even with the same government that needlessly killed 50,000 plus of my brothers and sisters. And my office manager says, you need an enemy. You're not happy unless you have an enemy. And I can't deny it. I like living on the edge. And back to the John Birch Society, they said, well, join. And I said, when you guys go into the lion's den, when you act like the ACLU and you file some lawsuits, class action or otherwise, you file some test cases, you get on the battleground, then I'll join. But you keep talking about, we got to learn more, we got to learn more. The joke was at the time, and again, I'm not bad-mouthing the John Birch Society, because because I think they did some great things to educate people. And they were the launching pad for a lot of freedom groups that I've seen in Arizona, Idaho, the West especially, other states. But they didn't want to act. And I said, unless and until you do that, then I don't want to join. They never did it, so I didn't join. Well, look at Irwin Schiff's case, the First Amendment case. Guess what? The ACLU is involved in that case. People know that? You talk about First Amendment rights when you look around this room. Free Enterprise Society, Paymon, Bob Schultz, they allow us to get up here and they provide the forum. And without them and groups like them, and Willis Carto, I've spoken at back in the old days of the Spotlight, he'd have these annual meetings. Without those guys providing the forum, I mean, it's one thing to have heroes like Dan Pill Sr. back there. Yeah, I got your attention, didn't I, Dan? This guy's a hero. I mean, if ever there's a hero, and he's got one of his posters up there about lawyers, and Jesus said, and I think in the Old Testament, or excuse me, it's in Matthew, thank you, in the New Testament, King James Version, I think something like, woe be unto you lawyers, for you have hidden the key of knowledge. He put them in the same category as the scribes and the Pharisees, because they've hidden the key to knowledge. So yes, knowledge is the first step. But now what do you do next? Well, let's talk about what you do next and what I've done. Let's talk about recruiting some young lawyers, because let me give you an example. There are law schools right here in California that offer full 3-year scholarships based just on the LSAT. It costs, a lot of these schools cost $22,000 a year in tuition alone. How do I know this? My oldest son, who's now a lawyer with me, got one of these scholarships at Chapman. Chapman, by the way, has a special tax program. Chapman has students involved in tax court and helping others. Paymon, we got to get you involved with Chapman professors and the students. How do we recruit these people and educate them? Now, we don't want, you don't want to give them too much. You got to spoon feed them. You don't want to put them into a criminal case. You don't want to put them with a non-filing issue. But how about CDPs? Collection due process, all this easy stuff you can start with. So much of this has to do with the procedural roadmap. You just need to know, well, client comes to me, I got this tax problem. Where are you on the procedural roadmap? Have you been assessed? Well, you got the assessment issue, and after the assessment issue, you got a collection issue. Vernie, I want to talk to Vernie and Joe Bannister back here, but I don't understand why Vernie has a collection problem already. Maybe she's got a different strategy with her attorneys that I don't know about. Leo and Masters and I were talking about this. We need to coordinate among ourselves and share information. And yes, there's all these different strategies, and some of them work better than others. We need test cases. I watched the video. How many have seen the Galen Rose video on Section 860? Only a few of you. I'm sorry, Larson Rose. 861. Larkin Rose. 861, okay, thank you. Well, why not a test case? Why not? And there was a gentleman today showed me a bunch of material, and he said, what do you think? And I said, well, you got to pay the tax, file a claim for refund. They deny that, you file a refund suit and test it. Well, they say I owe over $300,000. Well, find someone else that owes maybe $500. Let him be the guinea pig. We heard a lot from Leo, and I agree with his analysis about executive, legislative, and judicial branches. We need to attack on all fronts. We need to look at what we can do in all those branches. And yes, we have this fourth branch, the administrative law, and that's so problematic because we got Supreme Court cases that say, what do they say? You got to have abuse of discretion by the agency. You got agency rulemaking. It's mind-boggling. So you've got to decide which front you want to pick, what kind of court case you want to choose, and make a test case. Now, where does all this take us as to recruiting? Well, we educate, we mobilize, we get young attorneys, we encourage them, we get people in high school, in college, we encourage them to go to law school. We pay their way. We, who's we? Well, some of you have some money, but you don't want to do anything else. Well, then find a young student, adopt them basically, provide a scholarship, and get them in law school and teach them this. What's the average age here? I'd say at least 55. We're the young people. Well, this is heavy-duty stuff. I mean, it's heavy for me. I suffer from information overload. Why don't I know it's 861 and 860? Because it ain't that important to me right now. But I can tell you, how many know about Judge Hatter? How many know that a federal judges brought a tax protester suit? Just a few of you. I didn't make this up. U.S. Supreme Court. Oh, you didn't hear about it in 60 Minutes? You didn't hear about 2020? You didn't hear about national news? Well, here it is, U.S. versus Hatter. This was decided May of 2001. I got it right here. Now you know why I don't know it's 861 instead of 860. I'm reading cases. I'm a lawyer. That's what I do. This is Judge Hatter, U.S. District Court judges, and a whole bunch of them sued and said, we shouldn't be paying Social Security tax. And won! Now, the reason, don't think, unless you're going to become a federal judge, the reason they won is the Constitution says no federal judge should have his pay reduced. Otherwise, the legislature, remember, we got separation of powers, then the legislature could control the judges by controlling their salary. And I'm not going to explain all that happened in the case, but they won on Social Security and lost on Medicaid. But my point is, these judges, all these years, were paying Social Security tax, and then one of them, probably Judge Hatter, was the first that came up with the idea and got a bunch of his brothers, band of brothers again, and said, hey, we shouldn't be paying this. And it went up and down the courts for, I don't know how, 5 or 10 years or whatever, until we ultimately had a decision by the U.S. Supreme Court. Speaking of the U.S. Supreme Court, the law in this land, whether you like it or not, is whatever 5 out of 9 Supreme Court justices say it is. That's why I went to law school at 30. I was a slow learner. It took me until age 30 to realize, hey, if I'm going to have any influence in this country, I've got to influence that shriveled up man in a black robe that's going to bring the gavel down and control our very beings. Lawyers, they control our existence. You can't beat them, join them, and then fight from within. You think the bar, the State Bar of Arizona, asked me to speak at a seminar? I don't think so. Not hardly. You know, I did speak at a lawyer's seminar because a federal judge had me in his court one time, threatened me with contempt, and introduced me to the marshal. He said, McPherson, stand around. I want to introduce you to this marshal because if you don't testify in this case, he's going to take you away. Well, make a long story short, the defense, they raised the attorney-client privilege. I stood on the privilege, and then they decided, no, they wanted me to testify anyway, so I testified. Well, he recommended that I speak at a seminar in Tulsa, Oklahoma, concerning the Oklahoma City bombing and what's going on in this country. And we debated. 2 defense lawyers, another lawyer, and I debated the federal judge and a federal prosecutor among all these nationally prominent lawyers. They couldn't understand why Oklahoma City. I mean, you know, aside from the conspiracy they don't even want to hear about, well, it's just, they couldn't understand McVeigh. Well, it's real easy. Ruby Ridge and Waco. And I told them, you know, I have all these clients that petition for redress of grievances. And it falls on deaf ears. Time and time again, they go into the courts. You say, well, test it. Go into the courts. And it falls on deaf ears because, how many have read Bastiat's What is the Law? I see it on the Freedom Law. What is the law? The law is truth. When you distort truth, you distort the law. It's called judicial tyranny. Well, have you seen some of it in this country? Well, there's a lot of it in this country. But as a lawyer, working the cases, going into court, you got to do the best you can. And you eke out some of these victories. And speaking of the victories, my book, Tax Fraud and Evasion, the War Stories. How many of you read it? Probably not too many. Well, you want to learn about 20 victories? How some of these men and women win their cases? My heroes, you heard Remember I said the other night, last night, I said, I'm really accepting that award. Thank you very much for my clients that inspired me. Then you heard Vernie today. What inspiration? I'll tell you inspiration of a woman. My favorite chapter in the book is chapter 4. It's about a woman, Jean C. Hilton. And when you talk about recruiting these lawyers, you tell them, you show them this book, and you tell them about how much fun you can have as a lawyer and not just deal with some boring issues. You can talk like they talked back in the 15 and 1600s. Now, Jean C. Hilton was charged with, I said seditious libel. She was charged with interference with IRS agents, obstruction of justice because she caused criminal complaint for trespassing against special agents who came on her property, where it said no trespassing all over the place. Well, we went to trial, raised First Amendment right to petition for redress of grievance. The judge denied my motion. We went to jury trial. The jury couldn't understand the First Amendment. They found her guilty. Just before sentencing, the judge, sua sponte, that's Italian, right, Pilla? No, that's Latin, I think. Sua sponte, on his own, set aside her conviction, ruled First Amendment, and then the government stupidly appeals. I say stupidly because on appeal, here's what I got to say. Government concedes that we have found no case in which criminal prosecution resulted from a situation similar to the instant case. If one limits his search to American jurisprudence, the reason is simple. Since the Bill of Rights, the right to petition has been accepted as such a simple, primitive, and natural right that even a prosecutor of the most perverted genius, this guy right over here, has not imagined such a vile prosecution as the one against Mrs. Hilton. And if one researches the full history of the right to petition, one is invariably led to its root, the infamous charge of seditious libel. You know what seditious libel was? If you said the king's a jerk, you were hung and quartered. If you said one of his ministers was stupid, you went to the tower for life. And you know what? We heard about the Star Chamber, I think yesterday. It was born out of the Star Chamber, and we hear today libel and defamation and so on. The truth is a perfect defense. With seditious libel, the truth was an aggravation of the crime. So if the minister was really stupid, that was even worse if you said he was stupid. So then I went on, and this is quotation, not just from this is what I wrote to the Fifth Circuit, the U.S. Court of Appeals for the Fifth Circuit. The charge against Mrs. Hilton cannot stand as it is illegal under the First Amendment right to petition, the common law, the law of the land, Magna Carta 1215, and as Jefferson declared within the preamble to the Declaration of Independence, the laws of nature and of nature's God. It is against this very risk of anarchy which Jefferson so eloquently justified, that the petition for redress guards. When you write a letter to your congressman or the IRS, that's a First Amendment exercise petition for redress. Then I said, well, the First Amendment is, according to the Supreme Court, interpretations by no means absolute, although the amendment does state in no uncertain terms, and you quote the language from Congress. Then what room is there in these words for regulation by law? Not enough, Mrs. Hilton submits, to criminalize the acts of a free-born citizen who files with the proper state authorities a genuine complaint against officers of the federal government. Now here's my favorite part, other than perverted genius. Maybe that's my favorite part. If Mrs. Hilton's conviction is to stand, what man will dare to open his mouth, much less to use his pen, against even the worst governmental administrators? Yea, even against a president who may be most corrupt, and even confesseth to it. And if Mrs. Hilton's conviction stands, it should then be denominated high treason. For it is surely, as it is a seditious libel, it is just upon the heels of treason. The charge against Mrs. Jean C. Hilton, a free-born sovereign citizen, is the most pernicious attack upon English liberty. Man, that was fun. You talk about venting, you talk about freedom, you talk about saying it. Where did I get all that? I got it out of a book by a gentleman by the name of Levy. It's called Origins of the Fifth Amendment, and he tracks all these trials, 1500s and 1600s, before the founding colonies. I mean, you want to go back to some times of when they really were developing sovereign citizens. You read some of that history, and it's really very inspiring. So this book outlines, well, more than outlines, it tells the details of 20 of my winning cases. I've tried over 55 criminal tax cases in federal court in 24 states. I've won about a third. Well, you say a third. Well, what happened to the other 2/3? Well, if I was a baseball player, a third wouldn't be bad, right? Well, when you're going up against the IRS, they win about 95% of their cases. And we can badmouth lawyers till the cows come home, but if Vernie didn't have Larry B. Kraft, maybe she wouldn't be in here this weekend telling us about her case. So, do we need lawyers? Yes, we need lawyers. We need Willis Carto and Bob Schultz and Steve and Leo, and we need all these people. So once we recruit them, what are we going to tell them? Well, let's tell them about another secret exposed. Bankruptcy. Paymon wanted me to talk about this. This isn't for everybody, but let's talk about some war stories here. Why do I call it secret exposed? Because it's another government lie. They weren't telling the truth to the people. The lawyers didn't know about it. It was passed back in, I think, 66, and I got involved in the late 80s. By the way, I didn't learn nearly as much in law school or at West Point as I do and have continued to learn from my clients. I'm not an internet surfer. I don't even look. I'm a dinosaur. I don't look at computers. I pay people to look at computers. I'm a hard copy kind of guy. I like to mark up on it. I don't want to go blind. Oh, there's some other people here like that. Okay, so I had a client that said, hey, Mac, you can discharge taxes through bank. I said, no way. There's a bad rumor going around since 66, and this was 20 years later. It's like 87. This bad rumor had been going around. Attorneys didn't know it could be done for the most part, and still today they have it wrong. By the way, the ABA puts on a seminar every year. They don't invite me. Wonder why. I tell them every year, hey, you got to get the truth out there on discharge of tax debts through bankruptcy. They have a woman that presents this seminar on the issue, but she doesn't hit the nail on the head. She doesn't tell them that non-filers can discharge tax debts through bankruptcy in a Chapter 13, for example. So as I researched it back in the 87s, I found sure enough my client was right. Make a long story short, I even wrote to the IRS, and I love Paymon's letter that he wrote. And by the way, he got really lucky, Paymon, with that response on your tax shelter issue. I've never a letter as nice as that and as thorough as that from an IRS agent and a revenue agent at that. But I wrote to IRS and I said, hey, you got fraud, publication 908. Those of you that want to do some research, go see if you can find publication 908. It's supposed to explain the rules for bankruptcy. And I wrote to them and I said, you don't have it right. You need to be telling them the truth. They wrote me a letter, and it's in the book. And they said, hey, you're right, and we're going to change a little bit of it. And they didn't really change enough of it. Let me go through the rules. I was going to show them on a slide projector, but I don't want you to put you all to sleep. And some of you don't need this, but you might have a loved one, a relative, somebody that's going to say, I owe $1 million, or I owe $300,000, and you're gonna wow them a little bit because you're going to give them some of these rules. Before I tell you the rules, I'm going to give you some bottom line war stories. We've discharged. I used to say millions, and it was tens of millions, a million. I just stopped counting because back when I wrote one of these early editions, I had over 4 million. Well, for one client alone, it was 15 million and a Section 6700 penalty. What are the rules? Well, 3 years is a rule that you have to meet in Chapter 7 and 13. I'm going to go through this kind of quickly, and I'm going to leave these books up here. By the way, as a paratrooper, I travel light. So there's the table I just created. It has free pens and my cards, and I'm going to leave my books up there. And the guy or gal who turns off the lights takes the books. Okay? That fair? In the book, in the last page, it has this. It's a timeline and all these rules summarized. And one of the keys is don't let them file lien before you file bankruptcy. You're in a race to the courthouse. I'm I'm going to tell you what I can do for non-filers. And I say I or any bankruptcy attorney if you understand the rules. And I don't do bankruptcies. I just evaluate your case and look at it. Let's say I got a non-filer that comes to me in Arizona, homestead exemption in Arizona is $100,000. They got property worth $250. They got a loan against it outstanding of $150. So they got $100,000 equity in their house. They owe $275,000 in tax debts, and they're all for, let's say, the last 10 years. In the last 3 years, they owe $25,000 of that. Here's what we can do in a 13. We can discharge $250,000, number one. Number two, they keep their homestead exemption because there's no lien filed yet. And number three, they pay the $25,000 in a plan of 3 to 5 years. Not bad return on their investment. What are they going to pay? They're going to pay a bankruptcy attorney probably $3,000 to do that. That's an example of some results in a 13. Now notice, important notice, to qualify in a 13, the person's going to have to file those returns. Hey, I came here with maybe an AK-47 and an M16 and a 45. I didn't say a 105 millimeter howitzer or 155 millimeter howitzer or an 8-inch nail gun. I can do just so much. We got a toolbox here, and we got all these people around here that are different tools. And I don't know if you want to call me a screwdriver, a hammer, or a saw, or a ladder, or what you want to call me. But I've got. Did you say screwdriver? Okay. All right. So, wrench maybe. Anyway, there's just so much each of us can do, and I'm just giving you information, so that's what I can do with a 13. But the guy's got to file the returns. Now, the irony of that 13 is this. By being a non-filer, he's better off sometimes than he is if he's a filer. Because in a 13, you have this, I call it a bad boy loophole, and I don't want to get into the technicalities, but in a 13, even if it's a post-petition assessment, meaning the assessment doesn't occur until after you file a bankruptcy, it's okay as long as you're a bad boy. You're either a non-filer, you committed evasion, or you filed late and you didn't meet the 2-year rule. It's a strange law. I didn't write it. Congress, in its divine wisdom or otherwise, did. Now, what we can do in a 7, for example. I've had clients that, by the way, before I leave the 13, the other irony in the 13 is the individual has no assessment. They have no lien because they didn't file, let me back up. They have no assessment or no lien because they didn't file returns, and if there wasn't a substitute for return, all these years have gone by, they haven't been assessed. That's why they can go into the 13 and then ambush the IRS with a discharge. In a 7, we've had results where, let me give you an example of an airline pilot was in a tax shelter, and then he was in tax court at the mercy of the tax matters partner. He couldn't do anything. He was at the mercy of this guy who got him into this because now only the tax matter partners can sign off on the forms. So the guy's in there for 10, 20 years even. He comes to me and says, I want to retire soon. I'm making $150,000 a year. It was $40,000 and now it's like $250,000 because of interest and penalties. And I want to retire, and my retirement is about $500,000 or $1 million. And I said, fine, here's what we're going to do. We're going to settle on the dotted line. We're going to sign off, have the assessment in tax court, hope the lien is not filed. By the way, the guy also had $100,000 equity in his property. We needed to save that. So we needed to beat the IRS to the courthouse to file a bankruptcy before the lien's filed. We sign off, we wait 8 months because you got to meet the 240-day rule. You got to wait 8 months from the time of the assessment. They didn't file a lien. He files bankruptcy, keeps his retirement pay, discharges $250,000, stays employed at $150,000 until he retires, keeps his homestead exemption of $100,000. Now that ain't a bad day's work. And remember, I said there's different talents out here, and God has chosen me, I believe, to do what I do. He's going to choose you to do these other things. There are so many success stories that take me all day long to tell you about all the success stories on the bankruptcies. The bad news, that's all good news. The bad news is Congress, it's now 4 years they've been trying to change this law. And they're at it again. I heard the House passed another version, and that's a whole nother conspiracy, and it's the lobbyists. You know, it's the same credit card companies that every week you get one of these notices from a credit card company inviting you to get a new credit card. It's the same credit card company that goes to Congress and complains that all these people shouldn't be able to file bankruptcy at all because all this money is being lost. Let me just say quickly what the rules are in the 7. The 3-year rule, the 2-year rule, 240-day rule, no post-petition assessment, return filed, and no fraud. What that means, I don't want to go into details just now, but the rule that applies to both the 7 and 13 is the 3-year rule, meaning the return had to be due, including extensions, at least 3 years ago. So 2000, for example, due in 01 plus 3 years is 04. No extensions come up April 16th of this year. 2000 and all prior years qualify for the 3-year rule. Chapter 13, not as many rules and a lot more beneficial. A 3-year rule, no 2-year rule, 240 days, that no post-petition assessment, but the exceptions I explained earlier. And then it's got limits. And the limits, though, increase every year, and it's about 300,000, round numbers, about 300,000 for unsecured and about 750,000 for secured. They want good faith, and then if the IRS fails to file proof of claim, which sometimes they do, then they lose. Now, back to my overall theme. What about these lawyers, and how are you going to recruit them? Well, don't overwhelm them. You got to spoon feed them. They can be independent. They can have their own business. They can learn from paralegals like Leo and others that Paymon deals with. They can take it step by step. They can move from civil, and by the way, I take a holistic approach. I look at civil tax, criminal tax, and bankruptcy. They can get involved in all 3 areas. And then you need to sell them on the idea that they can be freedom fighters. If you try to give them so much, they're just going to choke on it. And if you try to talk about non-filing and this and that, and by the way, that's what the courts call civil disobedience. Paymon obviously has learned from the libertarians and from others. He quotes Sun Tzu. Sun Tzu said, "He who fights and runs away lives to fight another day." I mean, that's guerrilla warfare. He's taken a holistic approach to how we can gain more freedom through all these different strategies. And I'm just one guy. I'm just one guy, though, that brings 25 years of experience to this lectern, thanks to Paymon and others. And I'm just passing off that experience to you. And again, you can eat, meet, and retreat, or you can go back and think, okay, who can I recruit into this movement? Who can I get to become a paralegal or a lawyer, and how are we going to do this? And law school, California is the best state in the country as far as law schools, because you've got all these unaccredited law schools, but you can still be a member of the California Bar. So if they're going to stay in California, forget the ABA and accredited schools. You got evening schools. Arizona's got, Greater Phoenix got 3 million people when they got one law school, and it's not even an evening school. You got people that can work and go to law school. You got to read a lot, but law is not nearly as hard as math and engineering and chemistry and all these other subjects. So in closing, and I'll be around, I want to hear Bob. I won't be around for too long after Bob speaks because I got to head for the airport, catch my plane. But I'll be around for a little bit. I'm going to leave these books over here. And I would encourage you to decide where, if anywhere, you fit in, because we need Jack McLambs, we need Sheriff Max as the next governor of Utah, but it's not just because I'm getting old and tired, but believe me, and Paymon will tell you, we need some more Mac McPhersons. Thank you. one bummer I forgot to tell you, it's an important bummer. For the lawyers, they got to toe the line, they got to file the returns. Well, they can be a loophole filer like I am. Have a corporation. I don't like corporations because of First Amendment rights and Fifth Amendment and Fourth Amendment and so on. But they can have a pension plan, pay minimum tax, be a loophole filer. You can't, the bar's going to come after you if you don't file. The IRS is not going to let you practice before the IRS if you don't file. So again, there's trade-offs and everything, and that's, we need different soldiers, different tools, and that's the trade-off. Thanks, Peter.
Thank you, Don. Yeah, we need different soldiers, different tools, different battles, and